that it's not to apply. So this court has to look at the entire proposition with all of its mitigating effects to say, when there's such mitigation, such beneficence, those two isolated words, and in Valencia, this court concluded, no, two isolated words would not eclipse the rest of the proposition. Here, why would two isolated words eclipse the rest of the proposition and demonstrate a sufficient clarity, especially when in that same section, currently serving is so close to completed sentence so that the electorate would know and be telegraphing to a court, we really mean Estrada not to apply, Estrada Kirk, not to apply, even though Kirk defendants have been bound with Estrada for a half century.
So one of the reasons that we cited in People versus Conley for taking a different approach in the context of the parallel provisions of the Three Strikes Reform Act was that the presumption that underlies Estrada doesn't hold completely. There is a substantive component to the resentencing scheme that requires a court to consider not only whether the new provisions that mitigate punishment apply to the person seeking relief, but also whether releasing that person after resentencing would pose an unreasonable risk to public safety. And in Prop 47, there is both that component, that dangerousness determination that the court has to make with respect to persons who are currently serving a sentence. And there's also, and I want to direct your attention and sort of hear what you have to say in particular about the statement of purpose and intent in the statute, in which the voters declared their purpose to, quote, require a thorough review of criminal history and risk assessment of any individuals before resentencing to ensure that they do not pose a risk to public safety. How do you understand the scope of that purpose?
Yes, I understand. First, it's a little bit risky to compare Proposition 47 to Proposition 36 because in Valencia, this court emphasized we're dealing with two entirely different populations of offenders. In Proposition 36, the three strikers, every three striker had committed a minimum of 2 serious or violent felonies. Here, there isn't a likelihood in many, many cases of that at all. So the real question is, and with no disrespect, the question may be putting the cart before the horse, because when you get to sentencing, resentencing, dangerousness becomes a component that the judge, in his or her discretion, must consider various factors in whether to resentence. But the primary question is, in which category does a defendant belong, a Kirk defendant belong? In the Estrada box or in the box where a person who has a final judgment and is currently serving?
But so the statement of purpose that I just read to you suggests that the voters intended a dangerous assessment for any individuals before resentencing. And if I understand your argument correctly, you would say, even though any individuals is on its face fairly broad, there is a category of individuals who should be entitled to resentencing without consideration of their criminal history and a risk assessment.
What I'm saying is that
it's just a yes or no question.
I'm sorry?
It's just a yes or no question. Is that your argument, that a category of individuals is entitled to resentencing without consideration of their criminal history or a risk assessment?
Yes. I was going to give an explanation, but if yes or no answer, yes. So in Valencia, the court also went to discuss various presumptions. And one of them is that the electorate is aware of existing laws. And presumably this court is concluding that the electorate is aware of Estrada. And the question is this coming down to, is the currently serving a sufficiently clear savings clause, given Your Honor's question, to put those individuals whose convictions are not final, even though the question is it sufficiently clear, given the whole span of the proposition that is so beneficent that they should be considered along with Estrada. Now, one part of the discussion is liberal construction. In our briefing, we have referred to liberal construction, which this court has employed recently in both Page and Romanowski. Even though we have discussed it, respondent has never attempted to reply to it. If it's to be liberally construed to affect the purpose, and the primary purpose is the reduction from felonies to misdemeanors for cost savings. If all that is to be affected, then the liberal construction should benefit Kirk defendants who are tied to Estrada defendants. And the respondent has never affected any type of response to that.
So a defendant is not currently serving a sentence under your definition.
Correct.
What is he doing, or she doing, actually?
Well, they have had judgment imposed, but they are serving a sentence, but they are
Serving
not
a sentence, but not serving a sentence?
No, they are in one definition. You might say in one definition they are serving a sentence. I'm not going to quibble with words. They are serving a sentence. But I don't think they are not serving a sentence which is final to take them out of the Estrada-Kirk principle of law that requires that Estrada-Kirk amelioration applies to them.
So just to make sure I understand your argument based on your answers to Justice Kruger and the other questions you've gotten, you're arguing that serving a sentence is a term of art if you read it in context in the statute, and once you do, then it's ambiguous enough that we have to go to the Estrada presumption.
Correct.
Thank you.
If there are no other questions at this time, I'd like to reserve.
Thank you, Mr. Cohen.
May it please the court. Proposition 47 makes its retroactive intent clear. Appellant continues to emphasize differences between Prop 47 and Prop 36 and the overall purposes of Prop 47, but that's not the issue here. This court made clear in Nasalga that the Estrada inquiry is not about the overall motivation behind the law itself. The question is whether the law expresses its retroactive intent. Estrada is a presumption. When a statute reduces punishment, it's presumed to apply to all non-final judgments unless there's evidence to the contrary. Just as in Conley, here there's evidence to the contrary. The plain language of Section 1170.18 specifically applies to anyone who is serving a sentence. A person who is either serving a sentence or they're not serving a sentence. Those who are serving a sentence may still be eligible for relief. They just have to file a petition. This really should end the inquiry. It's not necessary to get into a discussion of the overall purposes of the law and how broadly it reaches, and if it's different than Prop 36 or any other law. Appellant has a mechanism for obtaining relief. She can file a petition and ask that she be resentenced. but she has to file that petition. Proposition 47 makes its retroactive intent clear, and the people respectfully request that this court affirm the judgment. Unless this court has any questions, I'll submit.
Just one question,
Absolutely.
off the beaten path. Is a defendant who's granted probation serving a sentence?
Yes, Your Honor.
Thank you, Ms. Acosta.
Thank you.
The court had very few questions of respondent. The respondent did refer to Nassauga, and it was in Nassauga that the court referred to sufficient clarity. And the court, in questioning me in opening argument, referred to, was it sufficiently ambiguous of what the electorate wanted or desired in lieu of the Estrada Kirk principles and what currently serving would have meant or does mean for, quote, currently serving versus, and as I try to emphasize, in juxtaposition to completed sentence. Well, Nassauga is the case that talks about sufficient clarity. And if this is where the rubber meets the road, if this court looks at it, can this court say there's sufficient clarity when the electorate takes out the pamphlet and reads it throughout the ballot materials? I don't know if the court still has that pamphlet. You can look it up online. And currently serving is at the very end. And the description in the beginning of the ballot materials, the legal analysis description, is not that clear about currently serving versus completed. And it's very brief compared to all of the substantive changes and all of the cost savings. And one cannot come through reading that without a conclusion that the true focus was the amelioration. And once that is driven home, and the question is, does the elector, does the voter leave the booth, having read it, with the belief that currently serving in that one sentence means that Estrada and Kirk defendants are divorced from the relationship they've had for a half century?
Thank you, Mr. Cohen. Ms. Acosta, the matter is submitted. In the matter of Inri Vicente Benavides Figueroa on habeas, we welcome the Honorable Mark B. Simons, Associate Justice, Court of Appeal, First Appellate District, Division 5, sitting assignment. You may proceed.
Good afternoon, Your Honors. May it please the Court. I am Paula Fogg, appearing on behalf of Vicente Benavides Figueroa. Mr. Benavides has spent the last 24 years on death row, convicted of murder based on false evidence that even the state's own experts characterize as an anatomically impossible cause of death. Respondent has conceded that the evidence supporting the sex crime convictions, special circumstance findings, and first-degree murder conviction is false, and that it is material within the meaning of Penal Code Section 1473, entitling Mr. Benavides to relief. In light of these concessions, this court should reject respondent's requested relief of reducing Mr. Benavides' sentence from first to second-degree murder, and instead reverse the conviction and remand the case for a new trial. My argument is centered on 3 points. First, I will argue why reversing the conviction is the appropriate remedy under the law. Second, I will argue that should this court find that it may reduce a conviction in a case of false material evidence, the facts of this case do not support that as appropriate relief. And last, I will argue why, even if this court finds that it may reduce Mr. Benavides' sentence, it may not do so before ordering a reference hearing where the remaining disputed facts relating to the false evidence claim and ineffective assistance of counsel claim at the guilt phase have been resolved. Turning to my first point, this court has never reduced a sentence in a case involving false material evidence. In re Richards in 2016, this court decided that the crucial question in a case involving false evidence is the materiality of the false evidence and not whether there is sufficient evidence once the false evidence has been removed. If a sufficiency or reasonable probability test cannot be applied to the crime of conviction, it is not appropriate to apply it to a crime of which the defendant has not even been convicted. A determination that the false evidence is material means that there can be no confidence in the outcome and that the sentence should be vacated. Moreover, there is no authority for a reviewing court to reduce a sentence after engaging in a wholesale re-examination of a trial record after the false evidence has been purged from the record. Respondents' request for relief requires this court to excise false evidence which permeated every aspect of the prosecution's presentation of the evidence and argument in the case and assess a sentence based on a re-evaluation of a new record which is entirely different from the record that was before the jury. Respondent cites no authority for the court to do this. The cases cited in the return deal with the sufficiency of the evidence, with the determination of materiality, and with the court's powers to reduce a sentence in a case where, due to prosecutorial vindictiveness, the defendant faced augmented charges. In none of the cases did the court sit in judgment of a petitioner after excising false evidence from a record and engaging in a re-examination of a new record untainted by false evidence. Turning to my second point, even if the court accepts respondent's position as legally available, a new trial is still the appropriate remedy in this case for three reasons. First, Mr. Benavides' due process right will be violated by having this court make a determination about his guilt to a crime that includes elements that were not included in the crime of conviction. Second, the false evidence permeated the entire trial proceedings, and it isn't possible to excise it from the trial record and obtain a clean record on which this court can rely with confidence. And last, to make a determination of what a jury reasonably probably might have found, this court would be required to engage in functions that fall squarely within the jury's purview. It would have to make fact findings and credibility determinations on a record that is entirely different from that on which the jury relied. Second-degree murder is not a necessarily included offense in the crime of conviction. In Castañeda and Hoverter, this court decided that when felony murder is the special circumstance in a death penalty case and the jury finds the special circumstance true, it has necessarily found the defendant guilty of murder under a felony murder theory. Malice is an element of second-degree murder that is not included in felony murder. The jury in Mr. Benavides' case unanimously decided that Mr. Benavides killed Consuelo in the commission of a rape and or sodomy. It did not consider necessarily or much less found malice proven beyond a reasonable doubt. Criminal defendants have a clearly established due process right to have a jury make the determination about every element of the crime of conviction. This court, therefore, cannot make a finding about malice without having any indication that the jury considered it. Second, the evidence of sexual assault permeated the entire trial proceedings, and it isn't possible to obtain a reliable record that is clean from that taint. In his opening and closing statements, the prosecutor did not once refer to physical abuse without also using in that same sentence some wording for sexual abuse. Although the prosecutor advanced two different theories, there was no the characterization of the main dispute in the experts' opinions was whether Consuelo was sodomized to death or whether she was sodomized, raped, and then beaten to death. The sexual abuse was completely tethered to the physical abuse. The prosecution emphasized to the jury that the injuries to Consuelo's genitalia could not be explained by anything other than sexual abuse. And the prosecution used the false evidence to cross-examine the defense theory. And the false evidence of sexual assault served as the primary challenge to every expert presented by the defense. The prosecution relied on very prejudicial, inflammatory photographs of Consuelo's genitalia to allegedly show to the jury how Consuelo had been sexually abused. And so pervasive was the sexual abuse allegation in this case that even this court, and I'm quoting from the appellate opinion, wrote that with the exception of the radiologist, every single expert who testified about the medical treatment of Consuelo was asked to describe Consuelo's genitalia. The prosecution credited the pathologist's cause of death finding, which is anatomically impossible, and the pathologist's conclusions of rape and sodomy over the opinion of every other expert. The false evidence is so intertwined with every aspect of this case that to try to excise it from the record and obtain a clean record would be as difficult as trying to obtain a clean glass of water from a poisoned well. Third, to make a determination of what a jury reasonably probably might have found in the absence of false evidence, this court would have to engage in functions that fall squarely within the jury's purview. Absent the false evidence, this court would sit with an entirely different record from what's in front of the jury. And absent the false evidence, there would be a number of factual disputes that the court would have to resolve. For example, there is the dispute of what caused the abdominal injuries. There were two defense experts that testified that the abdominal injuries were consistent with having been hit by a car. But the prosecution's experts, Drs. Dibden and Diamond, testified that the car accident was not a possible cause of the injuries. There is the factual dispute about whether Consuelo would have necessarily suffered contusions and abrasions as a result of having been the victim of a car accident. Defense expert Dr. Baumer, who was an emergency room doctor, testified that he had seen many kids who had been hit by a car and showed no road burn or other abrasions. But the prosecution expert, Officer Esme, testified that he could exclude a car accident as the possible cause of the injury because Consuelo had no contusions or abrasions. There is also the factual dispute of what caused Consuelo's rib injuries. Dr. Baumer, the defense expert, testified that he had never seen ribs fractured in that manner by a child being squeezed by an adult. But the prosecution experts testified that Consuelo's rib injuries, were caused by having been squeezed and pulled back. There is the factual dispute of what caused the injuries to Consuelo's head. She had swelling in her head and brain infarcts, and Dr. Benson testified that they were the result of multiple blows to her head, having been hit in the head, and of possible suffocation. But there is a wealth of information now before this court showing that both of those injuries were a result of her declining medical condition. Mr. Benavidez' right to a trial by jury would be violated by not having a jury make the determination of the facts on which the conviction can rest. And my last point is that should the court decide that the presentation of false material evidence can result in a reduced sentence, the court first needs to send this case back for a reference hearing because there are a number of factual disputes about false evidence that have not been conceded by respondent. And this court needs to assess the cumulative effect of the entire false evidence presented, as well as the ineffective assistance of counsel before making a determination. Unless the court has any questions, I will reserve the rest of my time for rebuttal.
Thank you, Ms. Hall.
May it please the court. Following our concession, the issue here has been significantly narrowed to the question of whether it's reasonably probable that but for the evidence that we have admitted qualified as false evidence, petitioner would have been acquitted entirely of any form of murder. And under the evidence...
Wasn't really tried as a malice murder case, was it?
It was tried under both theories. The jury was instructed on, first of all, the information alleged malice murder. The jury was instructed on both express and implied malice and premeditation, and the prosecutor referred to both kinds of malice as well as premeditation and second-degree murder in his closing statements. So that theory certainly was before the jury, and it was before defendant from the time of the charging document.
Okay, I just want to give you a chance to speak directly to this issue. This is among the most hair-raising false evidence that I've encountered in all the time I've been looking at criminal cases. I have a really hard time concluding that the average juror would do anything other than say, really, he did this to this little girl? I don't care what the evidence is. You're going to have to argue me off that position.
Certainly, Your Honor.
Just not to give you a difficult task or anything.
I appreciate the heads up. The evidence here was undisputed that the victim was left in petitioner's care for a maximum of 15 minutes, and that when those 15 minutes were over, her pancreas had been torn in half by being smashed against her spinal cord. Her intestine had been smashed in half after being crushed against her spinal cord, and several of her ribs had been fractured. That evidence did not depend in any way on the evidence of a sexual assault. And in fact, there was a dispute at trial whether the sexual assault caused those. One witness, Dr. Dibden, the pathologist, testified that the tearing of the pancreas and duodenum was caused by sodomy. However, there were several witnesses on both sides that disagreed with that and testified that they did not believe it was caused by that, and instead that it was caused by blunt trauma.
Well, but therein lies one of the problems. With this kind of evidence of sodomy, rape of a 21-month-old baby, and this vicious attack in 15 minutes of such a sexual nature, it precluded the jury from realistically considering any other possible perpetrator or the possibility that the child wandered outside and was hit by a car. This evidence, if it's harrowing to experienced judicial officers, to a jury of 12 people, they didn't hear anything else, frankly, and it precluded the possibility of other theories of non-liability or theories of causation, because it was so galvanizing and horrible. That's the problem. It's not just the duality, the dueling of the experts. It was this bomb that was dropped on the jury. They couldn't hear or see anything else after that.
But there were several experts, including 3 prosecution witnesses, Dr. Diamond from UCLA, Dr. Block from Kern, and Dr. Shaw from UCLA, that testified that they believed that the fatal blows to the pancreas and the intestine were results of blunt force trauma to the abdomen and were unrelated to a sexual assault. There was testimony from both defense experts, Dr. Lovell and Dr. Baumer, that basically agreed with that. And the prosecutor, in his closing argument, said that he didn't endorse either theory. He said, for the purpose of liability, that it didn't matter whether it was inflicted by a blunt force blow or by sodomy. But the weight of the evidence was that it was by a blunt force blow. And the test here is what happens when we remove...
You keep coming back, and I appreciate why you do, to the notion that there were conflicting experts and all the rest. But this just seems to me to be the prototypic example of 352 kind of prejudice. The nature of the evidence put forward by an expert who the DA chose to call, with charitably quite a checkered professional background, was so alarming that it's hard to say that at least one of those jurors didn't say, you know what, if he did this to this baby, I don't care what happened. He's going down.
Well, Your Honor, first of all, there's a presumption that the jury did its job, and I would also characterize the evidence a little bit differently. I would characterize the sexual assault evidence in a manner consistent with what this court said on direct appeal regarding some of the photographs, that it was disturbing but not gruesome. This is different. This case is different than a lot of child abuse and sexual assault cases in that the evidence...
on that. It certainly is.
The evidence is entirely clinical. The evidence regarding a sexual assault consisted of doctors testifying about the nature of those injuries and doctors testifying about their interpretation of what those injuries meant. And I would draw a distinction between that and a lot of other cases that this court would hear and that we see in the criminal justice system where there's a narrative describing a sexual assault against a child. And I would submit that that's what's really more disturbing and potentially prejudicial than something that's presented with such in a clinical atmosphere like this case. And what's more, the question of prejudice and inflammatory evidence is very contextual. It can depend on what the overall nature of the case is and what the evidence is. And in this case, the evidence of a sexual assault is not any more inflammatory than the evidence that this child's pancreas was crushed and split in two against her spine, that her intestine was crushed and split in two against her spine, and that several of her ribs were broken. So what I'm hearing for the court is something that a notion that this is uniquely prejudicial and that the jury would be so prejudiced that we can't apply the materiality test. And I don't think that's the case. I think the court needs to apply the materiality test, taking account, of course, any prejudicial effect, but I don't think the prejudicial effect in this context is that great, especially when we consider that there was abundant evidence that the fatal injuries were imparted by a blunt force blow to the abdomen, injury evidence coming from both sides, and the prosecutor didn't reject that. If you take away all that evidence, the false evidence, and you're left with him being left for 15 minutes with her and these occurring, and the taking away the false evidence doesn't affect the evidence about a car accident, not a
Well, you know, on paper, it can possibly be able to separate some of the descriptions of the injuries of this child. On the other hand, the forensic pathologist who testified in front of this jury said the cause of death was blunt force penetrating injury of the anus, with the anus expanded to 7 or 8 times its normal size. Another doctor testified that she suffered the blunt force injury to her abdomen, but testified that sodomy could have caused the injuries to the abdominal organs if the penetrating force ruptured the rectum, then pushed the internal organs aside until reaching the pancreas and duodenum, splitting them apart. I think it's a lot to ask a lay jury to separate how these experts are saying these injuries occurred with the other more clinical aspects of the organ's state, and be able to say clinically that this evidence in no way tainted the jury verdict in the sense of being able to find malice for second-degree murder. It just doesn't seem possible.
Well, without the sexual assault evidence, though, the evidence left is that she was killed by an extreme blunt force injury to the front of her body. And the sexual assault evidence the absence of it doesn't exculpate the identity issue. There's no evidence that any other agency other than petitioner caused caused the injury. She was in his presence alone for at most 15 minutes. By his own version to the police, she was out of his sight, by his own version, at least by no more than 1 minute. And he told, there is no evidence, to respond to something that the Chief Justice said earlier, there is no evidence that a car accident occurred here. And that issue is separate and unaffected by the false evidence concession. There was no evidence that his version was that he found her in the sidewalk right in front of the door. It's undisputed that there was no tearing of her clothing. There was no gravel or dirt in her clothing. There was no road rash, no abrasions that were consistent with the car accident, not to mention the fact she wasn't in a place where one would expect her, where she would be after a car accident. The prosecution's expert from CHP, Bill Esme, testified that she had not been in a car accident, and he gave that opinion, and he specified, he was asked if he'd give that opinion independent of the evidence of a sexual assault, and he said yes, he would. He also said he had never seen a case where someone was hit by a car and you couldn't see signs of on their clothing of the impact, and there was no such evidence here. There was also evidence from other medical witnesses. Dr. Block from Kern testified he didn't see any external trauma that he would expect to see with an auto accident. Even the defense expert, Dr. Baumer, testified that he would expect to see abrasions on her clothes and skin if she had been hit by a car on the pavement, and the records gave no indication of such. He also admitted that he had no expertise on the mechanics of what happens to a child when she is struck by a car. And so there's no actual positive evidence of a car accident, and the evidence, to the contrary, there is negative accident evidence. There's evidence that it didn't occur. Another factor showing that.
Well, okay, so it's possible that the jury would conclude that the car accident theory is not a terrific theory for the defense. However, as you recount the fact, it's hard to imagine how we get to second. We have a man who's in an apartment with 2 small children, no ill will apparent, no conflict between the defendant and this little girl that's reported by anyone. They're together for 15 minutes, and for no discernible reason, the DA's theory is, he decides to, or currently the people's theory is, he decides to batter this child with such force as to inflict these injuries. There are a few gaps in that testimony. I mean, it basically comes down to he was with her and she died, so it must have been him. And he must have done it for reasons we don't know, but they must have been malicious. That's quite a case.
Your Honor, I think when a child has these injuries, injuries like this don't just happen. The testimony at trial was, and no one has contradicted this, was that it takes a great deal of force to inflict those injuries. What's more, I would also, 2 other points on that. One is, I would point to evidence which this court recognized in the direct appeal, that there was substantial evidence that he had caused the fractures to her ribs that occurred several weeks before. And this court recognized that and described that evidence as substantial on direct appeal. Secondly, there's further incriminating evidence based on his contradictory statements about what had happened. His first statements, his initial statements to the victim's mother and to her sister Christina were that the 21-month-old victim had started running after Christina when Christina went outside to play. Christina, by the way, testified that this was not true. He made these statements before they went and at the first hospital, Delano, when the only apparent injury was a bruise to her head, and it wasn't known how serious the injuries were. There is no evidence, of course, and it's undisputed that her fatal injuries couldn't have been caused by running into a door. But then he changes his story the next day when he talks to the police after Consuelo has been moved to Kern Hospital, after she's been operated on and it's become clear how very severe and grave her injuries are. He talks to his police and then he changes his story. And now he changes his story to say that, well, he heard the door shut, he didn't see anything, he found her outside, right outside the door, and she was laying there and vomiting and bloody. Only then does he change the story. And that evidence is refuted by several things. One is testimony, including by the defense expert, that after suffering these injuries to the duodenum and the pancreas, the little girl wouldn't have been able to get up and walk to the door. Secondly, a criminalist looked at the scene. There was no evidence of any blood or vomit outside the door on the concrete, and no evidence that any had been cleaned up. On the contrary, the evidence, they found some of the vomit in a garbage can inside the apartment, and it had carpet fibers in it, which indicates that she vomited inside, which supports the notion that she never went outside. There were additional...
Let me ask you, though, all that you say, don't argue with, but the question about the remedy here that you assert is reduction to second degree. And I understood counsel to say that there are a number of unanswered questions yet to be decided about much that's been said here. And so could we get to second degree, notwithstanding Justice Corrigan's question? Wouldn't it require a reference hearing, and wouldn't it require an IAC determination?
I don't think so, because the IAC claims go to the issue we're conceding. So most of them have been rendered moot by our concession regarding false evidence of a sexual assault, and our concession as to the degree of the murder, the special circumstance, and the death sentence. The one I can recall remaining that could be relevant to liability is a statement by Dr. Hegler that in a declaration that she thought it could have been a car accident. However, that's irrelevant. First of all, that's irrelevant to the question of materiality of false evidence because it wasn't before the jury at trial. Secondly, it doesn't show any kind of an ineffectiveness claim because defense counsel had already retained at least two experts, Dr. Lovell and Dr. Baumer, and Dr. Baumer testified that he would have expected to see abrasions and signs if the girl had been hit by a car, and he didn't see them. So in terms of the competency prong of Strickland, he hasn't made any showing that counsel was incompetent with regard to that. And in fact, given that counsel hired experts and presented experts that testified about this issue, it's worth remembering, as I believe it's the Ninth Circuit said, that attorneys aren't required to scour the globe to find an expert that agrees with the point they'd like to make. Defense counsel did her homework with the experts here and presented them, and they dealt with the issue of a possible auto accident. What's more, if we were to go to prejudice under Strickland, Dr. Hegler's declaration on this point is weak. First of all, she says she thinks an accident occurred, but she doesn't deal at all with the absence of tearing on the clothing, the absence of abrasions, the absence of dirt or gravel, all the factors that or the mechanics of how a child would be thrown to the ground, a child of that height after being hit by a car. She doesn't deal with any of those, so her declaration isn't convincing at all in light both of the evidence presented at trial, not to mention the evidence presented in the declarations of Drs. Corey and Crawford. So there's clearly no, under both prongs of Strickland, there's clearly no incompetent performance and no prejudice.
What about the failure to object to evidence by the sister, purportedly a 9-year-old, by the way, that months after this little girl's death, this sister suddenly remembers that there was a time when this defendant was alone with the little girl, and he must have done something to her then. And the sister testifies and is not asked about any of that by the defense. That's a very interesting adversarial approach to testing the evidence.
Are you referring to the fact that she wasn't cross-examined about those statements?
Well, first of all, I'm wondering how she even gets to testify about that at all. And secondly, if she's allowed to testify without, or if there's evidence that actually the mother gives that testimony first.
Correct.
The mother says, months after the murder, my 9-year-old came in and said, oh, by the way, here's some interesting things you might want to know. And that evidence comes in without objection? That seems most irregular. And then the daughter herself does testify, and this late-breaking news, very late-breaking news, is not inquired into on cross-examination. There sure seems to be at least an argument to be made about the competence of counsel
Well,
here.
certainly, if we're going to Strickland on that, we can go straight to the prejudice. There's been no showing of what evidence, what that cross-examination would have elicited. And that is a prime element of any claim under Strickland of ineffectiveness.
Allowing the hearsay in without objection.
I again, would go to prejudice.
Counsel, I'm sorry to have to push you so urgently, but as I recall, you said, oh, there's all kinds of evidence that he was probably responsible for broken ribs before.
Yes, as this court acknowledged. But even without that evidence, if we're talking Strickland now, even without that evidence, there's still convincing evidence that he inflicted these injuries.
So if I understand your position, we should reweigh the evidence to reach a verdict of second degree on a theory that was only glancingly asserted at trial. And we should do our own Strickland evaluation without a reference. That's your position?
My position, I'd like to reword it. My position is that this court should apply the materiality test as it does in every false evidence claim, which is equivalent, as this court has said, to the Watson test and harmless error, and apply it the way it does in every other case where materiality or harmless error under Watson come up. It should examine the remaining evidence and determine if that was the only evidence that had been presented, is it reasonably probable that he would have been acquitted of all murder? And I would also, going back to something Your Honor said, remind the court that the prosecutor did discuss malice, premeditation, implied and expressed malice in closing argument, and the jury was instructed on it. And I agree that there was a lot of evidence presented on sexual assault here, but that's because that was what there was to contest. There just wasn't much to contest a petitioner's liability with. There wasn't much to fight it with because the evidence was so powerful that he was responsible. There was more evidence with which to contest. So the fight here was whether he was guilty of special circumstance murder and thus eligible for the death penalty, because there just wasn't that much to conflict the evidence of his liability for homicide with. And I think when you look at the fact that he was alone, the improbable nature of his varying statements, and by the way, he also told, besides the varying statements I mentioned, he told his mother the girl had been hit by a car, and then he told his cousin that Consuelo had been hit by a car and left in the street. And as this court noticed on direct appeal, those false statements are highly relevant to consciousness of guilt. And I think especially in view of how he switched his statement after it became clear that her injuries were serious. But here, the evidence, based on the nature of the evidence that he was alone with her, the nature of the uniquely severe nature of the injuries, the abundant evidence remaining that it was caused by a blunt force injury to the stomach, the presence of his numerous inconsistent statements, in addition to the prosecutor's argument that it could have been a blunt force injury and the overall instructions, it is not reasonably probable that if we take away the sexual assault evidence, that petitioner would have been acquitted of all murder.
Counsel, what's the most powerful legal argument for not granting relief from the judgment in its entirety? We've talked about a lot of things. We talked about the presumption the jury tries to, do its job, about the evidence. But what's the single most powerful legal argument?
The single most powerful legal argument is applying the materiality standard that was defined in Malone and is equivalent to the Watson standard, that there remains such abundant evidence that he killed this girl with a blunt force blow to the stomach that it is not reasonably probable that he would have been acquitted of murder but for the sexual assault evidence.
Thank you.
That's the core of our argument. Unless there are any further questions, I will submit.
Thank you.
I disagree with a few of the statements made by respondent. First of all, respondent said that that the prosecution's own expert testified about an abdominal injury causing her death, Consuelo's death, and not necessarily that it was only Dr. Dibden who presented the sodomy cause of death. And that is not correct in the sense that every time that any expert, whether it was a prosecution expert or a defense expert, testified about a different theory for the cause of death, the prosecution asked the expert who is in the best position of explaining the cause of death. And everyone said the pathologist is in the best position. So even if there was a dispute presented, the experts in the end ended up deferring to the pathologist's cause of death finding or to his opinion because he had a higher expertise. And the prosecution made a big deal out of the pathologist's expertise in his closing statement and compared qualifications and all of that to emphasize to the jury that it was the pathologist's cause of death finding that the jury should rely on. With regard to there being no physical evidence supporting the defense theory that Consuelo might have been hit by a car, that is just absolutely not true. In part, there is some evidence that was suppressed at the time of the trial in the form of plant material that was found in Consuelo's pharynx that supports that she might have been outside, but also there were grass stains on her sweatshirt and there was dirt and blood on the sole of one of her shoes that clearly indicates that it is possible that she was outside. With regard to Mr. Benavidez's statements, I have a couple of things that I would like to raise. One is that he has steadfastly maintained that he does not know what happened to Consuelo. From the first time he was questioned and until today, he said he was cooking, he turned around, the girl was coloring, then she wasn't there and he found her outside. He did speculate a number of times about what he thought might have happened, but he has always said that he did not know what happened. Moreover, this is a monolingual Spanish-speaking client, and there are a number of issues with the translations and interpretations that were provided when he was questioned. And he should not be faulted for poor translation. With regard to the...
Am I correct that the interrogation was conducted in English?
So it was in Spanish, but with a poor, it was like an officer conducted the interrogation and his Spanish wasn't great.
Okay.
With regard to the materiality standard, I think that I'm actually a little bit confused about what respondent is suggesting because in Malone, the materiality standard is Richards, there is materiality. That has been considered in this case. That's it. In Malone, there was materiality about just one portion of the case. It just dealt with one of the special circumstances that was stricken. It's not like the court did not reweigh evidence after excising part of the record and then like figuring out whether there was sufficient evidence, which this court said is not the appropriate inquiry when there is false evidence. And respondent has conceded materiality. With regard to the ineffective assistance of counsel, I also want to raise that there are a number of false evidence allegations that even the state-owned experts, they agree with petitioner that the evidence presented was false. Respondent has not conceded that that is false evidence. So there are a number of issues, disputed issues, that so the concession about false evidence only affects part of the ineffective assistance of counsel. Moreover, so two things. One is that respondent did concede ineffective assistance of counsel in the informal response, but then retracted that concession in the return with regard to how counsel proceeded with regard to the rape allegation and the special circumstance relating to the rape. Moreover, clearly, if post-conviction counsel, by presenting post-conviction experts and actually even the state presenting their experts with a full medical record, we get an agreement across the board that the evidence was false. Had counsel done that, it's just a matter of showing what happened to this girl when she showed up at the first hospital. She did not have any injuries to her genitalia. She was not bleeding. There was no information that would have caused any doctor, and which most experts actually suggest that had she suffered those injuries, they would have been visible. She just, in the course of their hospitalization, in the course of all these doctors trying to save her life, a lot of things happened, and because this girl was dying, there were a lot of physical injuries that ended up being interpreted as sexual assault, abuse that was not sexual abuse. And counsel clearly performed deficiently, but by failing to provide her experts with a full medical history. With regard to the broken ribs, I just have to point out that when she was brought to the first hospital, there was an x-ray taken of her chest, and the first interpretation of that x-ray was that there were no broken ribs. So there clearly are just like so many factual disputes. And so much of this goes to the sexual abuse that it's just not possible. Like, it really is not a case where you can just like strike a word out of a couple of pages from the reporter's transcript and get like something on which a court can rely and make a determination. So just to sum up, the appropriate remedies to reverse the conviction and remand the case for a new trial. First, based on the court's precedent, that a petitioner is entitled to a new trial or to relief when there is a finding of material false evidence introduced at the trial. Also, because based on the fact that respondent is unable to prove that in the absence of false evidence, the jury found malice beyond a reasonable doubt, and the court cannot make a determination about malice that the jury didn't make. Third, given that by excising the false evidence from the trial record, this court would be forced into the role of a fact finder, because the record would be entirely different from that which was before the jury. And last, because the false evidence infected the entire trial proceedings, as this court has made a point of reminding respondent. And the prosecution, I tried to count how many times he used some wording relating to sexual abuse, whether it was molesting, sodomizing, raping. And I stopped at some point. It's like more than once in every page of the reporter's transcript of the prosecution's opening and closing statement. It is really difficult to think of a crime that is more disturbing than the murder of a little girl, a 1.5-year-old girl, in the course of a brutal rape and sodomy. And Mr. Benavides has lived on death row for more than 2 decades, labeled as the perpetrator of this horrible, unsubstantiated crime. The court should not place any additional hurdles and should reverse his conviction and remand for a new trial.
Thank you, counsels. Matter submitted. We stand in recess until tomorrow morning at 9 a.m.